million Kenyans, and therefore they have to pursue the matter to the very end. And as Duncan Heimber reports, it seems the legal come political battle royale is far from over.
As the Attorney General prepares to stage his final attempt of rescuing the BBI train that has been pushed off the rails twice by two courts, BBI promoters say the struggle continues.
The initiative was supported by over 4 million Kenyans. Their overriding sentiment is that we must pursue this matter to the very end.
We want to keep pushing because we are determined to ensure that some of the very novel proposals in the BBI are not lost. And if they have to be lost, it must be known that we made our best efforts to secure them. There is the real possibility of a national crisis if some of the BBI provisions don't become law.
The Secretariat admitting that their only hope now lies in the apex court, the Supreme Court.
We believe that the two lower courts failed to appreciate the delicate balance needed in resolving an issue like the one before us. And only the Supreme Court judges have both the vocation and the mandate to do so.
Just like the lower court, the 7-judge appellate bench also declared the BBI referendum push null and void.
We are determined to soldier on. If the lessons of the past are to be our guide, the BBI too will come to be realized if we fight hard enough, and we are determined to fight hard enough.
Appeal Court had also called out Suna East lawmaker Junet Mohammed for pushing for a popular initiative, yet he is a sitting member of parliament.
Even the parliamentary way is open to Wanjiku. Wanjiku can give a member of parliament a petition to parliament to do a constitutional change.
Hatungekuwa hapa, si tungerekebisha hii kitu na tungeondoa ile makosa iko ndani yake. Lakini sasa kwa vishindo na nguvu na kifua walisukuma BBI. Sasa saa hii imeanguka, wanajaribu kunilaumu mimi. Sasa mnanilaumu namna gani? Na niliwaambia mapema iko matatizo na hii kitu. Vile niliwaambia si ndio hii wameambiwa na mahakama.
Attorney General Paul Kihara Kariuki will be formally filing the petition at the Supreme Court next week. Duncan Heimber, KTN News.
All right, so now let me bring in Mutula Kilonzo Jr., the current senator of Makueni County, into this conversation about that standoff that is supposed to be heading to the Supreme Court. And so even as the BBI case now heads to the Supreme Court, I want us to look back at the issues prosecuted in that court at the Court of Appeal. And Senator Mutula Kilonzo, thank you so much for joining us here on KTN News Center this morning. Let me first of all begin this conversation by picking your mind on your take when it comes to the Attorney General saying that he's heading to the Supreme Court and now he's being joined by the BBI Secretariat.
Thank you for inviting me to speak about this issue. First, let me say that the Supreme Court of Kenya under the current constitution was set up for matters like these ones. The reason why this was put in place was to ensure that matters regarding the Constitution had a final say in the Supreme Court. So this is part and parcel of what was intended by the framers of the Constitution. Two, the matters are so grave as to the question of amendment that it will be very good, irrespective of its outcome. It is important that the highest court of the land gives its finding on this jurisprudence. The fact alone that a ruling by the Court of Appeal was read for 10 hours and it's 1089 pages is a matter that itself needs investigation by the highest court of the land, because I don't believe that the judges of the Court of Appeal were just writing 1089 pages for the sake of it. It is important. It is important for the country. As I say so, I must make myself very, very clear that the appeal by the proponents of BBI and the Attorney General for purposes of the referendum are extremely academic. because the purpose of the push was to ensure that we have a referendum before the election. Going by what has happened in the Court of Appeal, this appeal is only for academics, for jurisprudents, for students of law and any other proponents of a constitutional amendment. This cannot be part and parcel of our election cycle. You can imagine the arguments, you can imagine the ruling and how long it took. It's obvious that an appeal of this nature in the Supreme Court will last until sometime in December.
So Senator Mutula, according to you, there is no need for the Attorney General and the BBI Secretariat team to head to the Apex Court.
No, I'm saying there is no problem with it, but they are doing it for jurisprudence and academic purposes and not for what it was initially intended for. The intention of this bill was to have constitutional amendments before the elections. Going by the precedent of what has happened in the Court of Appeal, it will be impossible to do all those things, have a referendum and have an election. I'm just saying, let them do that for the record. But let it not be an excuse that we cannot have an election because we have a BBI pending in the Court of the Supreme Court, the ruling came late, and those sort of things. That's what I'm saying.
All right. So, Senator Mutula, from where you sit, are you seeing some politics at play here? Because we're seeing, the president saying, okay, I do agree with the court's ruling, but then again, here we come to see the man who advises the president and also argues out the issues to do with the country's decision legally, saying that I'm going to the court to challenge the applicability of the basic structure doctrine that the judges talked about, remit of the constitutional amendment by popular initiative and the presidential immunity. On the other hand, we saw Honorable Raila Odinga, ODM party leader, saying, I will not move to the highest court of the land, that is the Apex Court. Yet we are seeing some of the BBI Secretariat team, Jeanette Mohammed and Honorable Dennis Waweru, these are people who are connected politically very closely. They're seen as the foot soldiers of these two senior political leaders here in the country.
No, I'm not sure whether I follow what you're saying, but if you are suggesting that the appeal is being filed for political purposes, it cannot be. This is a legal process. And the president is right. The president says that he respects the ruling because he should, but he disagrees, which he can. And therefore, the appeal is by the Attorney General is to say, can we have the highest court of the land pronouncing itself on the very basic issues that were determined by the Court of Appeal? By the way, this is not a very light matter. For purposes of the people who will come after us and the people who promulgated this constitution and fought for it, it's important the questions are addressed. For example, the Court of Appeal says that you cannot split, ideally every question that is in the referendum bill ought to be determined separately. Now, that is a matter that the Court of Appeal ought to determine so that for anybody who is proposing a constitutional amendment, by the time it goes to the people as a bill, a draft bill, how do you present it? Do you present it in the form of questions? Do you present it in the form of a bill? Do you touch Article 255, which they are calling the basic structure of the Constitution? This term, basic structure of the Constitution, is borrowed from jurisprudence that comes from other places like India, in a case called Keshav Bharati, which determined the basic structure of the Indian Constitution. Mm-hmm. What is the basic structure of the Kenyan Constitution, and how can you amend it? Because it cannot be contemplated that you cannot amend a Constitution. And it cannot be that difficult to amend a constitution. It must be clear, and it is important for the country to know, because we put an amendment clause. We can't have, as a country, put a constitution which we cannot amend. You can't make it so difficult. But so it's important that these questions are addressed in the Supreme Court, so that you know who is Wanjiko for purposes of Article 257. How do you exclude? Who do you include? I mean, if I'm a politician, Senator Mutula cannot be Wanjiko. So what am I for purposes of Article 257? Those are important questions. That's what I'm saying. Let's separate the political issues of the country and the legal questions of this constitution. Those are very important issues. I don't believe, and I don't agree with Jeanette Mohammed, that there are certain things that would cause a crisis if are not resolved before the election. That's not true.
But
this
then the
constitution has served us for 10 years. There is no crisis in the country, but we need those issues determined.
But then, Senator Mutula, the argument is they're going to the Supreme Court, they're supporting the Attorney General for the sake of the 4.2 million Kenyans who appended their signatures. And we had it very clearly from the High Court to the Appellate Court that said this process is null and void. The whole process being one, the IEBC was it was not fully constituted in terms of commissioners when they were even, approving the signatures that were collected. And also the president cannot initiate an initiative, cannot start an initiative of changing some sections of the constitution. This has to come from the common mwananchi.
Let me tell you why that particular finding is very interesting and why we need a determination. Do you know what that means? That means that the MP for Juja is in parliament illegally. The MP for Kiamba is in office illegally. Justice Musinga, who was elected through an election conducted by IEBC, is in office illegally. Those are fundamental questions that must be addressed. So how do you determine that BBI for purposes of IEBC is unconstitutional and the elections for purposes of satisfying the Elections Act are lawful? Those are findings that must be determined by the Supreme Court. That's what I'm saying. There are certain fundamental issues that must find a footing in the Supreme Court for purposes of determining whether, and determining this question, if IEBC has been improperly constituted since 2017 or 18 when the other commissioners resigned. Does that mean all the actions, including all the elections that have been conducted, including one of Senator Kabindi in Machakos, are illegal? Those are fundamental questions that might affect even our elections themselves.
All right.
I'm saying it's important that those issues get a determination by the highest court of the land.
All right. And yesterday when the Secretariat was talking, I had Junet Mohammed saying very clearly, and let me quote what he said. He said, "We believe that the two lower courts, that is the High Court and the Appellate Court, failed to appreciate the delicate balance needed in resolving an issue like the one before us, and that only the Supreme Court judges," he goes ahead to say that only the Supreme Court judges have both the vocation and the mandate to do so. That means they lack faith on both courts that had actually given the ruling that did not favor them. So from where you sit, Senator Mutula Kilonzo, with the legal mind that you have, is there a possibility of the Supreme Court judges overturning the ruling of the Appellate Court?
Now, Junet Mohammed is not a lawyer by profession. Let me explain. That is called the hierarchy of the courts. The courts don't have to agree with you. The High Court is not a lower court. The High Court is the High Court of Kenya and is given that mandate by the Constitution. The Court of Appeal is also is not a lower court. It's a court for purposes of a matter this delicate. So it's not the vocation, and it's not that you trust the Supreme Court. The Supreme Court can easily agree with the Court of Appeal and the High Court. In fact, in the case of the High Court, the Court of Appeal, in fact, annulled one of the findings of the High Court with regard to the President. That is also a matter that, for purposes of the people who are challenging or who are supporting, might go and determine and say, can you relook at this issue that the High Court found that the President was culpable and the Court of Appeal did not find? Can you check whether the Court of Appeal was right? So on the questions framed by the Court of Appeal, and there were so many, and please read the judgment of Justice Musinga, 21 of them. Mm-hmm. You never know. The Court of Appeal, the Supreme Court might agree with 10, disagree with the others, and that is allowed. And that is why, for purposes of the hierarchy of courts, the Supreme Court is the highest court, and that gets the final determination for posterity. And for purposes of the future of our Constitution and the country, it is important we have a final finding.
All right.
Important, very important.
All right. Thank you. So Senator Mutula, today is Katiba at 11, the Constitution at 11. Yeah. So why is it so hard for the country to change the Constitution, some sections of the Constitution right now, and like back then in 2010? when Kenyans went, voted, and changed the constitution?
I believe that is part of the questions that were before the Court of Appeal and even the High Court. Because there are two distinct areas: the area of the process and the area of the context and what is in the bill. How do you amend a constitution? Who is supposed to move? Possibly in 2010, 209 to 2010, it's possible we did it differently. If you recall, that process was led by my late father in terms of what is public participation. In fact, one of the fundamental questions that the Court of Appeal has raised, and which is part and parcel of what needs determination, is what is it that constitutes public participation? The promoters say we have 4 million signatures. The Court of Appeal doesn't think that the public knew what they were signing. So it's important that this issue is addressed. Up to what extent can you say you have had public participation on amendment of a constitution? And I must repeat this statement. We cannot have a constitution that appears to be cast in stone. That is not the purpose of a constitution anywhere in the world. A constitution ought to be amended. If you go to developed countries, they have referendums every other day. You find people on the street, they have a referendum, they change this and the other. It's supposed to be a living document. It's not a stone that we cannot move. So the question of what constitutes public participation, up to what extent can you tell Kenyans that they are aware about clause A, B, C, and D? What is it? Is there 1 million signatures enough for purposes of determining that you have given the public enough information? These are important questions.
All right.
Thank you.
All right. And as we finish this conversation in a minute, Senator, kindly use the minute that I'm giving you. So what does this mean politically for your party leader, Kalonzo Musyoka, Moses Wetangula, and also Musalia Mudavadi? Because after the Supreme Court, after the Court of Appeals ruling, we saw them changing their tune.
I don't know what the change of tune. I mean, you're making it suggest as if they were dancing and they stopped dancing. They supported BBI because they believed the part. And let me be honest. I mean, very candid about it. There are very progressive clauses in this proposed amendment bill that should have seen the light of day. It's very unfortunate that some of those clauses have gone away with the rest of the bad clauses. And I can tell you that BBI has some very bad clauses that are extremely a clawback of the 2010 gains.
All right.
So what it means is that Oka will proceed as if you have no BBI.
All right.
So their plan B is to move as with the current constitution. There was no vacuum. It's unlike the 2010 situation where we were repealing the whole constitution. The country must understand that we were amending sections of the constitution. We were not repealing the constitution. And therefore, it's not a crisis. We have no crisis.
All right.
We're not replacing the constitution, therefore there's no vacuum.
All right.
We move on. Thank you.
All right. Thank you so much, Mutula Kilonzo Jr., the Senator for Makueni County, talking to us here on a KTN News Center this morning on the way forward for the BBI Secretariat team that has said it will be joining the Attorney General Kihara Kariuki in appealing the appellate court's decision. They will be moving to the apex court, the highest court in the land, to get the final verdict, the minds of the senior judges in this country at the Supreme Court of Kenya. So allow me to take another short commercial break here on KTN News Center. I'll be right back in a